Think ignorance is bliss? Think again. On Know Your Laws with Debbie Ayinla, we believe ignorantia legis, non excusat. Ignorance of the law is no excuse. Join us every Wednesday by 12:15 p.m. on Unilag Radio 103.1 FM as Debbie breaks down the laws that shape our lives and keep you informed. Stay smart, stay aware, and know your rights. Only on Know Your Laws with Debbie Ayinla.
I was walking outside at City Hall. I slipped and had a terrible fall. Negligence on the part of a don't care who. I felt so hard I was seeing stars, dollar signs, men from Mars, and the man who helped me up said I ought to sue. He was a lawyer. He was all out of breath. Well, once I had an accident. Not too bad, just a little dent. New Mercedes hit me from the rear. A man got out in a three-piece suit and asked if $1,000 would do it. I said, well, let me think for a minute here. Gotta talk to my lawyer. Might have whiplash, might have trauma. Let's not talk petty cash. I got a witness, put a hand on the Bible. Jury, jury, hallelujah, you might be liable.
Good afternoon, listeners. Welcome to another episode of Know Your Laws here on Unilag 103.1 FM. My name is Debbie Ayinla, and thank you for tuning in. Know Your Laws is a legal program where we discuss relevant issues in the society from the perspective of the law. This is also a program where we ensure that every one of you listening is conversant with the fundamental laws of the Federal Republic of Nigeria, starting from the 1999 Constitution to all sorts of statutes and regulations. We always dissect issues from the standpoint of the law, and this afternoon I am privileged and honored to have one of our finest, one of the most intelligent professor in the Faculty of Law, University of Lagos. Today we are discussing plea bargaining, which is a legal process that allows an accused person to negotiate a lesser charge or penalty in exchange for a guilty plea. So we're going to come to all of this, and to help us to dissect all this is my guest for today, Professor Akeem Bello. He is the professor of the Department of Public Law in the Faculty of Law, University of Lagos, like I said earlier. And Professor Bello's principal areas of research are substantive criminal law generally, bribery and corruption, criminal justice, and restorative justice. I knew criminal law because of this, my professor. Good afternoon, sir.
Good afternoon. It's my pleasure to be here.
And as a matter of fact, he has an article on plea bargaining, which is titled Regulating Bargaining to Achieve Acceptable Criminal Justice Outcome in Nigeria. So we are in good hands. Good afternoon, sir.
Thank you. I also have a book on plea bargaining titled Overview of Plea Bargaining in Nigeria.
Overview of plea bargaining. Oh wow. So if you're listening, you should get a copy of that book. Good afternoon again, sir. Thank you, sir, for joining me. I'm so honored. Quickly give us an overview of what plea bargaining is about, the history, the origin, and all of that, sir.
Yeah, plea bargaining is an arrangement whereby a defendant who has been charged with a crime or who is about to be charged with a crime enters into negotiation with the state represented by the prosecution to plead guilty to a lesser charge or to plead guilty to the same charge in return to a lesser sentence for an offense. It is essentially a means of disposing a criminal matter.
Okay, sir.
And it came about as a result of the fact that we have challenges in the administration of criminal justice in Nigeria. There are a myriad of challenges. And one of it is the prolonged delay in the administration of criminal justice. So plea bargaining came up as a tool that enables us to be able to dispense criminal justice quickly, speedily, and efficiently without sacrificing the demand of justice, without sacrificing the need to ensure that an offender who has committed an offense is punished for the offense that he has committed, and without prejudice to ensuring that the rights and interests of the victims of crime are duly protected. Now, it came into Nigeria around 2004-2005.
Okay.
That was when, the concept came into criminal justice in Nigeria. And it came up in relation to some of the cases prosecuted by the Economic and Financial Crimes Commission around that time.
Yes, sir.
Particularly, it was used in a case involving one Nwude, who was alleged to have defrauded a Brazilian bank, and after defrauding the Brazilian bank collapsed. The fraud, was in tune of a sum in excess of $100 million.
Wow.
So when the prosecution started, there was some delays in the prosecution, and the leading prosecuting counsel and the defense counsel thought it fit that the defendant would plead guilty to some of the counts of the charges that were preferred against him in return for a lenient sentence. And in addition to that, the defendant also forfeited to the Brazilian bank, a sum in excess of $100 million. And he was sentenced to 5 years imprisonment. Now, that was the very first case that was plea bargained in Nigeria. And that case, epitomizes the value of plea bargaining in achieving quick dispensation of efficient justice, in ensuring that the defendant gets due punishment for his crime, in ensuring that the defendant, is stripped of the proceeds of crime, because in that case the defendant forfeited to the Economic and Financial Crimes Commission, and the money was eventually paid to the beneficiaries of the Brazilian bank, over $100 million. But the irony is that the other cases that were plea bargained around that time did not actually achieve such a fair outcome, thereby giving the impression, a lot of people felt, they've come up with another, system to enable the rich and the mighty to escape, from being punished for their crime, another opportunity to give the rich and politically exposed persons a slap on the wrist, and so on and so forth. A lot of people don't make reference to this very first case. This case was presided over by Honorable Justice Oyewole. Is currently at the Court of Appeal now in Nigeria. It epitomizes the value of plea bargaining, and that plea bargaining can be used to achieve an acceptable outcome. But after that, we had some cases where some people pled bargain and they were given option of fine, and in one instance the person paid the fine and walked home free, even though he has committed a serious offense. So it's all these other cases that shape the public perception about plea bargaining around that early time, 2006, 2007, 2008, 2009. We had the Tafa Balogun case, we had the Cecilia Ibu case, and so on and so forth. But over time, because of the outcry, concerning this abuse of plea bargaining, a legal framework has since emerged.
Okay.
And in Lagos, came up with the first formal legal regulation of plea bargaining in the Administration of Criminal Justice Law of Lagos State, 2007. That was the first law in Nigeria that provided a comprehensive, platform for plea bargaining, ensuring that there are procedural safeguards to ensure that the accused person, once he pleads guilty, gets a sentence that fits the crime, despite the fact that he's pleading guilty. Yes, he will be given consideration by being given a reduced sentence for agreeing to plead guilty, but pleading guilty pursuant to a plea bargain does not mean that the offender will go completely scot-free, as we saw in the case I referred to earlier, against Nwude. So it has since spread, and it was adopted by the Federal Administration of Criminal Justice Act, Section 270 of the Administration of Criminal Justice Act 2015, and all the states have now adopted Administration of Criminal Justice law that provides, in one form or the other, for the use of plea bargaining in resolving criminal cases. So that, in a nutshell, is a brief history of plea bargaining in Nigeria.
Thank you, sir. I think the fact that the defendant pleads guilty does not necessarily mean he has to walk home free. And this brings me to one of the issues I wanted us to discuss. Was there was a news that was flying around last year, the cross-dresser that was found with money laundering, was charged with money laundering, and according to what he came out to say, he said his lawyer asked him to plead guilty, that if he pled guilty, the judge was going to reduce the sentence and all of that. But he still had to go through the sentence that was given to him that amounts to that charge. So that has been able to clarify that issue of the fact that you even pled guilty does not necessarily mean that you will still serve that punishment.
Yeah, let me quickly make a clarification there. The case involving the cross-dresser,
yes, sir,
was not resolved by a plea bargain agreement.
Okay.
There was no formal plea bargain agreement. When we talk about a plea bargain agreement, it's an agreement. The prosecution and the defendant will negotiate. They will enter into a written agreement. The written agreement will set out the terms of punishment, although the terms of punishment that is set out in the plea bargain agreement is only a recommendation to the judge, because under the law, the judge has a discretion whether to affirm the recommended sentence or whether to impose a lower sentence,
yes, sir,
or whether to impose a higher sentence, irrespective of what the parties have agreed. Now, in case the judge wants to impose a higher sentence, the law requires the judge to give the defendant an opportunity to make up his mind whether the judge should continue or whether he wants to withdraw from the plea bargain, in which case the case will go to another judge and start afresh.
Okay.
But in the case involving the cross-dresser, there was no formal plea bargain. It is true that they pleaded guilty.
Okay.
Okay?
Yeah.
But that guilty plea was not pursuant to plea bargain. Before we ever had plea bargaining in our laws, defendants have always had the right and the choice to decide to plead guilty. And usually when the defendant pleads guilty,
yes, sir,
they are accorded the benefit of a lenient sentence. Why? Because the defendant has accepted responsibility by pleading guilty. The defendant has also enabled the matter to be disposed of speedily without wasting the time of the court,
yes,
and the resources that will be expended by the state in providing for the prosecution. It is because of that defendants anywhere in the world, where a defendant pleads guilty, they are given a lesser sentence. So that was what the cross-dresser must have been hoping for in that case by pleading guilty. But that was not a plea bargain agreement, because there was no agreement filed in court. Perhaps if his lawyers had negotiated a formal plea bargain agreement on his behalf, the terms would have been more defined and the scope of the discretion of the judge would have been more clearly delineated.
Yeah.
In which case the judge would have said, well, I want to impose a lesser sentence, or I agree with the sentence, or I want to impose a higher sentence, in which case it will have been notified that the judge was not going to accept the recommended sentence, the judge was going to impose a higher sentence, and he will have been given the statutory option of deciding whether he wants to proceed with the plea bargain or not. But that did not happen in that case because it was not a plea bargain agreement.
All right, thank you, sir. So quickly, again, from what you just said, I know you just touched on it. I want us to dwell on who are the parties to this plea bargain agreement. Who are those that, is it the defendant? Who comes to plea bargain? Is it the prosecutor? Is it the court? I know you mentioned that the judge does has the discretion to decide.
Yes.
Yeah.
The parties to a plea bargain agreement are principally the prosecution and the defendant.
All right, sir.
And then usually the defendant is represented by counsel. He has to be represented because the defendant has a right to legal representation.
Okay.
There are some nominal parties. For instance, the victim of the crime, the complainant, the person against whom the crime is committed, is officially not a party to the plea bargain agreement. But the law requires that the prosecution and the court should protect the interest of the victim or the complainant. For instance, if the offense involves a property crime.
Yes, sir.
One of the things that must be provided for in the plea bargain agreement is the restitution of the property allegedly stolen or damaged back to the victim of the crime. Okay, so and it is the responsibility of the prosecution to ensure that the rights of the victim or the complainant is protected in the plea bargain agreement. Now, when the agreement gets to the court is not officially, the court is not a party to the agreement.
Okay.
In fact, the law requires that the court should not get involved in the agreement. But when the parties have agreed and have drawn up the terms of the agreement will come before the court. At that time, the court now has a discretion to exercise, because the power to award sentence prescribed by statute belongs to the court. So the court will look at the facts of the case,
yes, sir,
and determine whether the sentence recommended by the parties fits the crime. If the court comes to the conclusion that, well, yes, you are agreed to plead guilty, you are going to save the time of the court, you are taking responsibility for your crime, you will be given concession in terms of sentence, but the sentence must not be too disproportionate to the gravity of the crime.
Okay.
It must still be a sentence that fits the crime.
So that is when the court
although the court is going to grant him concession in terms of leniency. So that is at the point at which the court can intervene.
Okay.
So if the court feels that the sentence is way, below what it would have imposed, or does not fit the crime at all, then the court can indicate to the defendant and his counsel that it is going to impose a higher sentence, and then give the defendant an opportunity either to agree that the court should continue or to withdraw from the plea bargain agreement, in which case the court will strike out the case and the matter will go before another court. And the law requires that in the second trial, after a failed plea bargain agreement, the parties should no longer enter into any plea bargain agreement.
Oh, so you can only enter plea bargain agreement?
Yes, because if it fails and you're allowed to come again, then it can become an instrument of delay, which is one of the objectives for which plea bargain is instituted in the first place, to speed up things, to enable efficiency. Yeah.
And to reduce cost of resources and all that. Okay. So you mentioned that, Prof, you mentioned that the victim, the prosecutor and the state are meant to protect the victim.
Yes.
But shouldn't there be consent? Now, this is me just asking. Shouldn't there be consent of the victim as well? If you're going to have a plea bargain over me that suffered the loss, shouldn't I consent?
That's a very good question. Now, we need to realize that under our constitution, the prosecution is vested with prosecutorial discretion.
Right, sir.
The prosecution represented by the Attorney General of the Federation, led by the Attorney General of the state, with respect to federal and state offenses, exercises prosecutorial discretion. And that discretion, the Supreme Court has said in State and Ilori, is not subject to judicial control. Meaning that whatever they want to do, they have absolute discretion, whatever they want to do with prosecuting the matter. Okay, so ordinarily, the prosecution will carry the victim along by explaining to the victim, this is why we want to offer this man plea bargain, like in Uniwood's case.
Yes, sir.
The party will have explained to the victim, he's going to plead guilty, but we are going to be able to forfeit this amount, and this amount will be paid to you. So they will explain the process to the victim.
To the victim.
But the prosecution is not required as a matter of law to get the victim's consent. Yes, but ordinarily they will try and carry the victim along.
Okay.
Because it is possible for the victim to say no.
Yes.
But the prosecution, who is vested with authority to determine what is best in the public interest, may have a public interest justification to override the consent of the victim. So ordinarily, the prosecution will try as much as possible to carry the victim along, particularly by protecting the interest of the victim. Once the interest of the victim is protected, the victim's consent is not mandatory. And once the court is satisfied that by the provisions of the terms of the agreement, the victim's interests have been protected, even if the victim is saying no,
Yes, sir.
the court will, accept the fact that the prosecution, who is the master when it comes to deciding and exercising discretion in relation to prosecution, has exercised the best interest, exercised the best judgment in the interest of justice generally, which includes the interest of the victim.
I put it up on social media platforms that you were coming today. A couple of your students that you taught criminal law had questions for you, and I think we're going to come into that question when we come back from the break. There are so many cases of plea bargain, and some people are even saying, oh, it shouldn't pertain to corruption cases and criminal cases and all of that. And we're definitely going to come back. What are the types of plea bargain that we have in the Nigerian legal system?
Basically, there are two. You have a charge bargain. A defendant may be charged with the offense of murder. He may plea bargain with the prosecution, and the prosecution may reduce the charge to manslaughter. The effect of that is that in Nigeria, murder still attracts a mandatory death sentence. Whereas, if he pleads guilty to manslaughter, the sentence will be to a term of years. So that's a charge bargain. You may also have a situation in which the parties are negotiating the sentence for the charge before the court.
Okay.
The offender has been charged for a particular offense, and they are negotiating the sentence. Maybe the sentence for that offense is 7 years, and they are negotiating a reduced sentence of maybe 2 years or 3 years to the same charge. So that's a sentence bargain.
Okay, so we have the charge bargain.
So those are basically the two types that we have. Yeah.
All right, sir. Now let me quickly read that one question out. This is from Blessing. She says that, I don't know if you've heard about the current news of Sunday Jackson, the farmer that was sentenced to death for killing a Fulani herdsman in self-defense. Now, when I went through this question, I don't know if it has to do with plea bargain, but we'll get to it. The herdsman entered his farmland with a very sharp knife and started running after him. He was able to collect it and stab him in the neck while they were struggling. 5 judges presided over his case, and 4 of them sentenced him to death, but there was a dissenting judgment. Had all the requirement for a plea of self-defense, but the other judges have sentenced him. If you were one of the judges, what would your judgment have been? What is your opinion on the case generally and the judgments?
Well, that does not involve a plea bargain.
Yeah.
I've heard about that case, but I haven't had the time to read the judgment.
All right, sir.
Because when the basic issues that the court will try to look at when you are raising a plea of self-defense is to find out whether there was circumstances caused by the victim that creates in the defendant an apprehension of death or grievous bodily harm. And after there is an apprehension of death or grievous bodily harm has been created, then the defendant would then be entitled to use proportionate force to defend himself. If he's using proportionate force to defend himself, death result, then he will have a valid plea of self-defense. But if the source of danger had abated, in other words, there was initially a creation of an apprehension of death or grievous bodily harm.
Yes, sir.
And that apprehension no longer subsists because of certain circumstances. Maybe the assailant has withdrawn from pursuing his attack or his creation of fear of apprehension of death or grievous bodily harm, and the defendant still goes ahead to kill him, then the plea of self-defense may no longer apply. So I think those are just the general rules, which will then depend on the facts and circumstances of the case.
All right, sir.
Yeah.
Okay, so moving on, let's talk about the advantages for plea bargaining and disadvantage. I know that there will definitely be, because it seems to me as if, Prof, you're so passionate about plea bargaining.
Oh yeah, I'm one of the, I am privileged to have served on the committee that drafted the Addition of Criminal Justice Law of Lagos State 2007.
Oh.
And as a member of that committee, I was saddled with responsibility to come up with the draft provisions on plea bargain. So, by the grace of God, I can say that I originated the first draft on plea bargaining in the Administration of Criminal Justice Law of 2007 of Lagos State.
Wow.
And that initial provision has been replicated with some minor adjustment in the Administration of Criminal Justice Act 2015 and in all the Administration of Criminal Justice laws of all the states.
Wow.
So I mean, I'm very passionate about it, because I believe it is a tool that, if it is properly utilized, can bring a lot of advantages to our criminal justice system.
So you are for plea bargaining?
Yes, and that was why I cited that very first case, where it was properly applied, and where a proper sentence was imposed, and proper consequential orders were made to ensure that the offender does not, go away with the proceeds of crime. That was why I cited that case to illustrate the fact that properly administered plea bargain is good for our criminal justice system.
All right, thank you, sir. So let's see here the disadvantages of plea bargain and advantage of plea bargain, sir. Yes,
one of the major advantages of plea bargain is that it helps the court to manage their docket. Now, particularly if you look at the Administration of Criminal Justice in Nigeria, most of our courts are still operating at the very barest level in terms of efficiency.
Right.
The judges still write down proceedings, in longhand. Unlike in some locations in some of the more developed countries, where at the end of the proceedings you will receive the transcript of the day's
judgment
of the day's activities. So the process is protracted. That's a major problem. And then also on the part of the prosecution, there is no prosecuting authority anywhere in the world who has all the resources to prosecute all criminal cases that comes before them. No, there's no prosecuting authority. That's why in the US, over 95% of cases are plea bargained at the federal level. 95% of criminal cases are resolved through plea bargain. Because as the US Supreme Court said in the case of Santo Bello versus New York, without plea bargain, the American criminal justice system will grind to a halt. That is a system that even uses advanced technology, advanced investigative techniques, forensic technology, DNA facilities, to enhance the quality of their investigation and prosecution, compared to us here where we don't have those facilities. So you can then see that, there's a greater need for plea bargain here than even in these developed countries of the world. So that is the value that plea bargain brings into the system. And like I said, it can also be a tool for justice. And the defendant is given an opportunity to take responsibility. And if it takes responsibility, it can also, be made to take steps and measures that will address the impact of the crime on the victim, bringing in the concept of restorative justice. So it is a very good mechanism to use in resolving criminal cases. And now all the legal framework to ensure that it is properly done is in place. For instance, in Lagos, which is the trailblazer in terms of implementing plea bargain, in addition to the provisions of the law, the Office of the Attorney General has also adopted a plea bargain manual, which sets out the principles, the processes that the prosecutors will go through before agreeing to a plea bargain agreement. So it opens up the process to scrutiny and accountability. At the level of at the Office of the Attorney General of the Federation, the AGF in 2023 adopted a federal plea bargain guidelines for all federal prosecutors: EFCC, ICPC, NDLEA, Nigerian Police, NDIC, and so on and so forth. This plea bargain guideline sets out the procedure, the principle, the protocols to ensure integrity, fairness, and accountability, and all the federal prosecuting authorities signed up to it. Okay, so all these mechanisms and protocols are now in place to ensure that plea bargain, delivers effective justice. So those are the factors that makes it, a mechanism that we should use. We should continue to use in administering criminal justice.
I mean, Prof, I think that was a very beautiful explanation. You've been able to cover about 3 of the questions I have for you, and that's so extensive and well explained. And I think I love the fact that even now I'm beginning to be passionate about plea bargain. But another question here from one of your students again says, don't you think that the use of plea bargain for corruption related cases encourages looting, which allows wealthy or influential individuals to escape justice? Don't you think it should be used only for cases that carries lesser conviction sentences?
Thank you very much. Now, I've had to address this question in many of the workshops, that I've done across the states in Nigeria on plea bargain, because I've been privileged to do workshops for judges, prosecutors, defense counsel in Lagos, Edo, Anambra, Cross River, Kaduna, and currently ongoing at the Federal Capital Territory.
Wow.
Is the fact that there is no reason why the scope of offenses that can be plea bargain should be restricted. Because, it flows from the prosecutorial discretion conferred on the Attorney General and prosecutors by the Constitution. They have the discretion to decide what charges to file, when to continue, when to discontinue. And it is expected that they will use this power in the public interest. Now, one example that I used to give in my workshops to illustrate the fact that even for the most heinous of offenses, public interest may dictate offering the defendant a plea bargain. Let me give you this case, which I used to, share in my workshops. There was a county in the U.S., a local area in the U.S., where the police chief was assassinated, and a new police chief was appointed, and the government had reason to suspect that this new police chief was behind the assassination of his predecessor. In addition to that, they also had reason to suspect that he had some police officers working for him and that they were running a criminal network within the police. But fortunately, they were able to get evidence against the trigger man that he recruited to assassinate the former police officer.
Wow.
So in order to be able to get evidence against him and to bring down his criminal network in the police,
yes, sir,
the trigger man, the murderer, was offered complete immunity from prosecution. What that means is that he was allowed to act as witness for the state, and he was allowed to go scot-free. Not even a plea bargain. Why? Because there was a greater public interest need in bringing down this police chief who assassinated his predecessor. And also, is running a criminal network in the police. You can imagine the police calling the police to come and arrest armed robbers, and the armed robbers you are asking the police to come and arrest are police armed robbers. So it was felt that there was a greater need there was a greater public interest need,
yes,
to bring down this police chief. So and the only way was to use the trigger man, and they gave him complete immunity.
But Prof, why will they give him complete immunity?
I have just explained to you the justification.
He's a murderer.
I know, but I've just explained to you, and it has happened in Nigeria before. Hold on. He won't. Well, if he does it again, then he will be caught, and then he will no longer be entitled to plea bargain
and immunity
because he is a repeat offender. It has happened in Nigeria before. Sergeant Rogers, Barnabas Meshalia, alias Sergeant Rogers, the person who was known to have assassinated Kudrat Abiola, the state of Lagos, because the crime occurred in Lagos, gave him immunity from prosecution and used him as a state witness. He has never been prosecuted for killing Kudrat Abiola. So because there is a so there may be a public interest justification to give a defendant a plea bargain. Sometimes also, even serial killers in the US, have been allowed to plea bargain because they have killed people and their families don't even know whether those people are still alive or dead. But the serial killer is given an opportunity to plea to those offenses.
Yes, sir.
And for in those places where the death penalty is available, the concession they will give him is, okay, we will take the death penalty off the table. If you plead guilty to the offenses,
yes, sir,
at least the families will have closure. They will know that they don't have to be looking for their loved ones again because they have already been executed. They've already been assassinated by this serial murderer. So they give the serial killer opportunity to plea bargain. He will plea bargain and they will give him a reduced sentence of life imprisonment rather than what his conduct deserves, which is a death penalty. So you can see that there could be public interest justification in any offense. So that goes back to your question with respect to corruption. Corruption is an offense relating to stealing. Corruption is basically stealing public property. So if somebody has stolen public property, instead of allowing him to be in court for the next 15 years or 10 years, appealing from one level of the court system to another level of the court system, and he agrees to return the amount he has stolen, he agrees to return all the amount that he has stolen, and that does not mean that because he's pleading guilty he will go scot-free. Properly decided, was sentenced to 5 years imprisonment. He didn't 5 years imprisonment is not a joke.
Also it fastens litigation,
and then combined with all the other advantages. So there's no reason why corruption cases should not be open to plea bargain. But that does not mean that every corruption cases will be plea bargain. Remember, it's very important to remember this.
All right, sir.
A defendant does not have a right to plea bargain.
A defender does not have a right.
What a defendant has is a right to trial, fair trial.
Yes,
so whether a defendant will be offered plea bargain is entirely up to the prosecution, exercising their discretion in the public interest, in the interest of justice, and on the need to prevent abuse of the legal process. So it is only when the prosecution feels that we want to offer him a plea bargain,
yes, sir,
that's when they will offer a plea bargain. If they feel that they don't need a plea bargain, they are sure of their facts, all the evidence that they need to prosecute the case, everything is clear, everything is straightforward, they're not under any obligation to agree to a plea bargain. So it is for the prosecution. The prosecution must decide on each case whether they want to plea bargain, and that federal plea bargain guidelines that I referred to,
yes, sir,
provided criteria that the prosecution must follow in deciding whether they want to plea bargain, and also provided circumstances that indicates that the prosecution should not offer a plea bargain. So it is not in every instance that the prosecution. So the process, like I said, is now well guided,
yes, sir,
to prevent abuse.
Thank you, Prof. Professor Akeem has a book on overview of plea bargaining in Nigeria.
Yes.
Right. So how do we get the book, sir?
Well, I think it's out of print now, so I'm trying to.
So okay,
yes.
All right. So if you want to know more about this and all of that, please ensure that when it's out, I will definitely even be one of those to champion.
So it will be at the university bookshop.
At the university bookshop. All right, sir. And I will also try to make an.
No, I will get a complimentary copy for you.
Thank you, Prof. Thank you, Prof. Thank you. All right, quickly, because of our time, we have about less than a minute left. So what are your recommendations, sir, for plea bargaining in Nigeria?
Yes, my recommendation is that all the states that have not embraced plea bargaining should do so. They should do so. They should build the capacity. But before doing so, they need to build capacity to be able to apply.